with trespassing, which is unwarranted entry. The second is for more than a momentary period. If you see the definition of taking, I think this is an accepted definition for pretty much everyone in Florida as to what a taking is. More than a momentary period. And lastly, and I didn't underline this, but I think it's really as I got into this issue, devoting to public use is probably the most important part of the distinction between trespassing and actual taking, and that's the appropriation to a public use. You see here that we have kind of the elements of inverse condemnation, and I'm not going to spend a lot of time on these, but this is these come from the Sarasota welfare case. It's that was a physical invasion case. It's a second DCA case, and one thing that's not in here that I would want to give you all is a citation for the circuit court opinion, which I would consider to be one of the better reasoned physical invasion. It's a permanent physical invasion case, but this circuit court opinion I would consider to be one of the most well-reasoned cases we have in Florida. Unfortunately, it's from a circuit court judge. But the citation is 197 Westlaw, or WL 374688. And the issue with between the two, and the reason I point that out is that in the first one, they talked about a two-part test for physical invasions in Florida. One, whether there's been a physical invasion, and then they say that physical invasion has to cause a loss of beneficial use. That's what the second DCA said. Well, the circuit court, when it went back down, said, the second DCA wasn't really considering that. They didn't really know what they were talking about. When you have a physical invasion, it is a physical invasion. That's the standard. And so I would encourage you to take a look at that circuit court opinion. When we talk about the nature of takings, we've got permanent physical invasion is clearly recognized in both the state of Florida and the United States as a taking. Once you have a permanent physical invasion, that's a taking, regardless of beneficial use. That's what Loretto v. Teleprompter says. That's very clearly defined. Next, temporary takings have clearly been recognized since 1987. That's the first evangelical case came along. And so when you look at this issue, this gray area between the physical invasion, permanent physical invasions, and temporary takings, that 1987 date is important because we had another case in Florida, actually in this district, that's Gutierrez. And Gutierrez really said, no, there's no such thing as a temporary taking. And you had unfavorable treatment of temporary takings up to 1987. So it's always important to look at that. So the question that we have before us today is, what about the temporary physical invasion? And before I get into the government perspective, there's a case that's in your materials that's Hendler versus U.S. And that's a federal circuit case that really was the closest thing that I could find to being on point with this issue. And that was a case, it's actually a California case. It started in California where the DEP had instructed that there was some contaminated property, and they instructed that some wells be placed on a piece of private property. And in the midst of that, there obviously was a lawsuit filed, and it went on for years and years. And there was Hendler 1 and Hendler 2, as you kind of find in some of these federal circuit cases. But finally, they came down to this issue of whether or not these wells that had been placed on the property were permanent or were they temporary. And that's where we get that analogy about stopping to have lunch on a piece of private property. Is that a taking by government? I think everyone would agree that no, that isn't. But what about when the next day you come back and there's a government truck on your property? And the next day there's a truck on your property? And that they actually need that property for something. And so that's where that comes up in Hendler. And Hendler had a great discussion about what is a temporary taking. Because everything could be temporary, because the government could always change its mind. And most temporary takings cases have to do with regulation, where regulation was enacted, and subsequently brought back, well, what about that period of time when the regulation was affecting the piece of property? Well, Hindler said that also, that same logic applies to physical invasion cases. So I would encourage you to take a look at that case if you ever have this issue come up. There's really three things that come up when you're talking about temporary physical invasion cases, and that have come up in each of the several that I've had the opportunity to deal with since I've been working. The first is the taking versus damage argument. The second is public purpose, and the last one has to do with sovereign immunity issues that come up. Taking versus damage has got to be, that comes up every time. And it comes up because there's a lot of law in Florida that says that the government may damage property in Florida without incurring liability for a taking. And I think that's a true statement. But you've got to look at what exactly what goes behind that, because the government can't just go around damaging things without liability for anything. And the most important part about this issue is that they can't they can't invade it. They can't go on the property and damage it. Anytime there's a physical invasion, then this argument really goes out the window. I want to look something up here. I made a note of the jurisdictionally. This is important because certain states, and California would be one, where their constitution allows for recovery when private property is taken or damaged by government actions. And those taking or damaged states would be Pennsylvania, Alabama, Arkansas, Illinois, Missouri, Colorado, Texas, and California. And that's important because the case law gets wound together. And if you're dealing, it's important if you see case law in this issue come up, and it's not from the state of Florida, it's likely that it comes from one of those other states, because there's often an element of intent that's implied in the taking or damage states like California or Texas that we don't have here in Florida. Now you'll see the actual definition there where it says damages are the consequences of a legal act that come about as a result of no physical invasion. Again, if you've got a physical invasion case, this argument more or less goes